So in the old days, let's say somebody would come into the law firm with a $1.2 million estate. And what they would do is they would say, okay, if we leave everything to the spouse, this is back in the days when the exemption was $600,000. If we leave everything to the spouse, what's going to happen is the spouse is going to have $1.2 million. Then when the spouse dies, there's going to be tax on $600,000. So they used to make a trust. It was called the B Trust, and they would direct $600,000 to this trust. And the terms of the trust were health, maintenance, support, and income. And at death, it goes to the kids. The other $600 would go to the spouse. Then at the second death, the money in the trust was not subject to estate tax because the spouse didn't own it. They just had the income from it. There was a $600,000 exemption, so you could pass $1.2 million without any taxes. And this is what a lot of people did. In fact, I would say that this was the standard type document. As soon as the attorney saw more than $600,000, this is what they did. And the majority of the people who back then had more than $600,000, this is what they usually ended up with. And I'm sure there's people in this room that have that. So that's what I'll call the traditional plan. And this, by the way, this number is called the credit shelter amount. And the attorneys didn't write in $600,000 because they knew that the exemption kept changing. So they would put in formulas that would allow this number to change. But the formula was basically one exemption amount. Whatever that number is, that's how much money goes into the trust. Okay? The problem with that is what happens when the exemption amount goes higher? So let's say like today, it's $5 million. And I'm going to assume most of us don't have $5 million estates. And let's say you die with one of these old documents. And let's say that the money is in the person's name who died first. What's the document say? One unified credit shelter amount to the trust. Well, let's say that you don't have $5 million, you have $500,000, $1 million, $2 million, any number below $5 million. How much goes into the trust? All of it. How much does that leave the surviving spouse? Zero. Now think about this for a minute. Attorneys drafted trusts that were based on saving estate tax at the second death, and what's going to actually happen in reality. You're going to have an underfunded surviving spouse because the income, particularly today, if you're a conservative investor and you have at least half the money in bonds, you're getting maybe 2 or 3%. So even the income on $1 million might be $20,000, $30,000. That's not what the clients want.